Bismillahirrahmanirrahim. In the last video, we had discussed sources of international law, definition of sources, definition of international law, formal sources of international law, and material sources. As we already explained that we shall discuss the sources of international law in few lectures, in few videos, in segments, so that the viewers can easily comprehend the same. This is in continuity of previous one. Sources of international law. The important source of international law is customs. This is the first source of international law. The customary rules and principles were the major part of international law before the recent times. These rules had been evolved during the course of history after long process and their recognition by international community. International customs are the important source of international law, and the same has been recognized by Article 38 of Statute of International Court of Justice as main source of international law. Definition of custom. What is custom? As held in Chancery case in 1608, a custom in the is the law in such usage as had obtained the force of law. Uh, then the question arises, what is difference between a usage and custom? Generally, there is no difference between the terms custom and usage, as they are often used interchangeably. But according to strict analysis and circumstances, the both are different. Usage is the sundown stage of custom. Custom begins where usage ends. Usage may be an international habit of action that has not yet received full legal attention. The elements of valid international custom. There are three basic elements of valid international custom, which are the custom should be from long duration. It must be a regular and repeated habit or practice, and there should be uniformity and consistency in the custom and its observance to become a source of international law. In asylum case in 1915, it was held observed that the rule invoked should be in accordance with a constant and uniform stage usage practiced by the states in question. The same like principle was held in Ubeck case. In this case, it was discussed that a single act of a state agency or authority could not create any right of custom in favor of another state which had benefited by the act. Conduct to be creative of customary law must be regular and repeated. Circumstances of observance of a customary rule. What are the circumstances and what have been the circumstances in which the custom has been accepted as rules or source of international law? The first one is the diplomatic relations between states. Since the history, the diplomatic relations are based on custom, but in present days, nowadays, the declaration of the statesmen, bilateral treaties, legal opinions to state governments, and press releases by spokesperson of the governments may constitute evidence of a usage followed by states. Practices by international organs. The practice of international organs by conduct or declaration may lead to development of customary rules of international law concerning their powers, duties, and responsibilities, etc. And the third one is the state laws, decisions of state courts, and state military or administrative practices. State laws are the judicial decisions of the state courts, or the state practices have recognized the application of the customary rules. The Supreme Court of United States in famous case, the Scotia 1871, held that these rights and duties must be determined by the new customary rules of international law that have evolved through the widespread adoption of the British regulations. Therefore, the fault lay with the Berkshire. The famous cases of international tribunals, International Court of Justice regarding customs. The first one is the Portugal versus India case, ICJ 1960. The case was about the right of passage over Indian territory, and it was held that particular practice between two states, only which is accepted by them as law, may give rise to a binding customary rules inter parties. And Lotus case in 1927, the Permanent Court of International Justice had held that the opinion juris is a matter of inference from all the circumstances, not merely the detailed acts which constitute the material element of the alleged customary rules. Judicial application of custom, it is very important how and when the judiciary, particularly international tribunals and International Court of Justice, can apply the custom as a rule or a source of international law. The role of international and national courts has been remained praiseworthy in application of customary rules to disputes presented before them. Either of the parties before the court may submit regarding the existence of certain customary rules related to dispute. The court, after proper inquiry and examination of the other available materials, may declare the existence of customary international law. According to Mr. Justice Cardozo, the court will attest the jural quality of the custom. The Pakit Havana case 1900 is a very classical and celebrated case. The Supreme Court of United States, after thorough inquiry of materials such as state laws, practices, treaties, juristic writings, and decisions of the courts, found that they uniformly prove the existence of a valid customary rule providing immunity to small fishing vessels honestly pursuing their calling from vagrant capture in wartime. In Lotus case 1927, the Permanent Court of International Justice, after applying the above referred method, that is the inquiry and examination and the examination of other available material sources, held that there was no customary rule conferring exclusive penal jurisdiction in maritime collision cases on the country of the ship's flag. The sources of international law is very crucial question and has been repeated in exams of competitive exams as well as LLB and LLM exams. Therefore, as we already explained that we should discuss the sources of international law in few lectures briefly, so that it can easily be comprehended and easily be understand. So thank you very much, and in next video and next lecture we shall discuss the second source of international law, that is treaties. Thank you very much.